Welcome to Do It for the Case Law for Wednesday, August 26th, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today we are covering 61 federal appellate decisions across 5 reporter beats. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. Today we have 15 criminal justice cases across 5 circuits. The disposition roll-up shows 7 affirmances, 1 dismissal, 2 vacators with remands, 1 reversal with remand, and 1 split outcome where the court affirmed in part and reversed in part. Starting with the 8th Circuit, the court vacated Rodney McIntosh's sentence for unlawful firearm possession because the district court wrongly classified his prior assault convictions as crimes of violence under the sentencing guidelines, requiring a new hearing to determine if the statute involved violent force. Also in the 8th Circuit, Michael Vinton's supervised release revocation was vacated and remanded after the court found the district court abused its discretion by relying on undisclosed probation officer information without giving defense counsel a chance to address it. Moving to the 9th Circuit, prison officials lost their summary judgment in Grenning v. Key because the lower court applied the wrong legal standard for censoring inmate outgoing mail, which requires a heightened scrutiny rather than the deferential Turner standard. The 9th Circuit also affirmed Maziar Rezekani's supervised release revocation, rejecting his Confrontation Clause challenge regarding hearsay evidence since he conceded the plain error standard and failed to object at the hearing. Over in the 3rd Circuit, Congresswoman LaMonica MacIver won a partial victory where the court reversed the denial of legislative immunity for 1 count of assaulting federal officials, but affirmed the denial for 2 other counts involving physical acts deemed non-legislative, while dismissing her claims of selective prosecution for lack of jurisdiction. In the 11th Circuit, Richard Colvin's conviction for transmitting interstate threats was affirmed after the court rejected arguments about jury instructions and mental health evidence, while Christopher Messer's appeal regarding his 112-month sentence was dismissed because an enforceable plea agreement waiver barred his challenge. The 11th Circuit also affirmed Julio Rodriguez's denial of compassionate release, finding the district court properly weighed his violent history against the need for public safety, and upheld Kelvin Howard's convictions for drug trafficking and firearm offenses based on a probable cause affidavit supported by a verified confidential source. Additionally, Pedro Santa Cruz's 187-month sentence was affirmed as not unreasonable even if an error occurred regarding safety valve relief, since the actual sentence fell within the correct guideline range, and Ricardo Verdun Castro's request for a sentence reduction under the retroactive guidelines amendment was denied because the district court properly considered his extensive cocaine trafficking role. Finally, in the 10th Circuit, Kedrick Marshall's conviction for being a felon in possession of a firearm was affirmed as the court found reasonable suspicion justified prolonging a traffic stop based on a vinegar-like odor and nervous behavior, and the government's sentencing advocacy regarding uncharged conduct in United States v. Knowles did not breach the plea agreement. Back to you, David.
Thanks, James. Let's turn to Aisha for the civil rights coverage.
Thanks, David. We have 10 cases on the docket today. The disposition mix includes 4 affirmances, 1 dismissal, 2 reversals, and 3 split outcomes where courts affirmed part of a ruling while reversing another. First, in the 1st Circuit, Kyle Fellers and others were remanded regarding their First Amendment claim that Bow High School engaged in viewpoint discrimination by sanctioning students for wearing pink XX wristbands at a soccer game. The court found no evidence of material disruption or severe harassment, concluding the school officials punished the students based on disagreement with their anti-trans message. Moving to the 10th Circuit, Hewlett received a split outcome where his claims against county entities were affirmed as dismissed, but his Section 1983 claims against individual officers were reversed for remand because the complaint failed to allege facts showing clearly established violations regarding detention and excessive force. In the 11th Circuit, Hubert Arturo Acevedo also saw a split result. The court affirmed that city commissioners are not immune from his whistleblower retaliation claim, but reversed qualified immunity for the city manager, holding that terminating a police chief is an administrative act. The court also affirmed the dismissal of Civica Simpson's complaint, ruling it was a shotgun pleading that failed to separate claims against multiple defendants. Over in the 6th Circuit, Dennis O'Connor had his due process claims vacated and remanded because Michigan law treats the state as a custodian of unclaimed funds rather than an owner, preserving the original owner's property interest.
Finally, the 9th Circuit issued 4 routine affirmances, 1 approving a class settlement with Google where direct distribution was infeasible, another upholding summary judgment in an employment retaliation case, a third denying civil rights claims against Volunteers of America for lacking state actor status, and a 4th affirming summary judgment for an officer based on video evidence contradicting the plaintiff's account. Back to you, David.
Thanks, Aisha. Let's turn to Michael covering constitutional law and habeas corpus.
Thanks, David. 4 cases in this block. 2 were affirmed and 2 were vacated and remanded. Starting with the reversals, the Ninth Circuit vacated and remanded the habeas petition of Duarte against Rokowski because the district court erred by summarily denying a petition that raised a cognizable claim requiring service on the government and a response instead. Similarly, the Ninth Circuit vacated and remanded the habeas petition of Escalante Gonzalez against Mullen for the same reason, holding that summary dismissal was improper when a valid claim was alleged, and directing proper procedural steps before any merits determination. Moving to affirmances, the 11th Circuit affirmed the grant of summary judgment in favor of prison officials in Dombrowski v. Jelks, finding no deliberate indifference regarding safety boots or medical treatment delays for a hip injury under the 8th Amendment. Finally, the Ninth Circuit affirmed the summary judgment against Ruiz against Endusco, ruling that the inmate failed to exhaust administrative remedies under the Prison Litigation Reform Act before filing his medical needs claim. Back to you, David.
Thanks, Michael. Maria has the business and civil law developments from across the country.
Thanks, David. Maria Santos with 20 cases from the 1st, 10th, 11th, 7th, 8th, 9th, and federal circuits, covering contracts, labor disputes, securities, antitrust, torts, and consumer protection. The day's dispositions included 12 affirmances, 5 dismissals, 1 denial, 1 reversal with remand, and 1 split decision vacating part of an agency ruling. Let's begin in the First Circuit, where 1 lower priority case was resolved involving a dispute over contractual interpretation.
Moving to the 10th Circuit, the court affirmed the dismissal of a qui tam action alleging violations of the Federal False Claims Act and New Mexico's Fraud Against Taxpayers Act, holding that the relator failed to present specific record evidence demonstrating the defendants acted knowingly as required by the statutes. Over in the 11th Circuit, the court affirmed summary judgment for a financial company, ruling that a borrower's Chapter 11 bankruptcy filing triggered a full recourse event under Georgia law regardless of whether the petition was authorized or successful. Also in the 11th Circuit, the court dismissed an appeal regarding attorney charging liens, holding that such orders are not immediately appealable because they do not resolve an important issue completely separate from the merits and are effectively reviewable on appeal from a final judgment. Moving to the 7th Circuit, the court affirmed the dismissal of a complaint by a health fund against the Arkansas Insurance Department, holding that State Rule 128 is not preempted by ERISA because it constitutes permissible cost regulation rather than interfering with plan administration.
In the 8th Circuit, the court reversed and remanded a dispute involving locked-in companies, finding that while choice of law-informed selection clauses were enforceable, the lower court erred in its determination regarding customer non-solicitation covenants, which must be modified to apply only to customers with actual contact. Moving to the 9th Circuit, the court denied Boeing's petition for rehearing en banc, affirming a prior decision that reversed a judgment as a matter of law in favor of Zunum Aero on trade secret claims because patent inventorship counterclaims were permissive rather than compulsory.
The court also affirmed the dismissal of Eric Kickert's civil action challenging U.S. support for Israel due to lack of standing and instructed the district court to amend the judgment to reflect that the dismissal is without prejudice. Additionally, the 9th Circuit affirmed dismissals against the IRS in a pro se case for lack of subject matter jurisdiction, against an Oregon plaintiff seeking to quiet title for failure to establish federal question or diversity jurisdiction, and against Dorothy Lewis under the Rooker-Feldman doctrine because she sought to overturn a state court foreclosure judgment. The circuit granted review in a motion to reopen removal proceedings, holding that the Board of Immigration Appeals abused its discretion by applying a categorical rule limiting exceptional circumstances to serious illness or death without considering the totality of the petitioner's circumstances, including homelessness. Finally, moving to the federal circuit, the court affirmed a dismissal for lack of jurisdiction where claims were barred because related bankruptcy proceedings were pending in another court, dismissed 2 appeals for failure to prosecute due to unpaid docketing fees or missing briefs, and vacated part of a patent trial and appeal board decision holding that patent claim limitations regarding adding new services were not limited to managing existing ones. The court also affirmed a determination by the Department of Commerce that canvas banners fall within the scope of an anti-dumping duty order for artist canvas from China. 1 additional lower priority case in the federal circuit involving a dismissed appeal due to procedural failure was resolved today. Back to you, David.
Thanks, Maria. Let's turn to Raj, covering immigration and government.
Thanks, David. Today I have 12 substantive cases covering immigration appeals, administrative agency review, tax, and Social Security across the 10th, 9th, and federal circuits. The disposition roll-up shows 2 dismissals, 6 denials, 1 split outcome of affirmed in part remanded, and 3 affirmances. Leading with the split outcome, the 9th Circuit in Kickert v. State of Washington affirmed the dismissal for lack of standing but remanded to correct the judgment to reflect it is without prejudice, clarifying that taxpayer standing remains narrow under Hine while dismissing the appeal on other grounds as futile. Moving to the 10th Circuit, the court denied a petition regarding a motion to reopen removal proceedings for an Iraqi national, finding no material change in country conditions sufficient to excuse the filing deadline or establish Convention Against Torture eligibility, and affirmed the tax court's dismissal of William Veazey's appeal for lack of jurisdiction because the IRS had not issued a required notice of deficiency. In the Ninth Circuit tax and agency rulings, the court denied 3 consolidated petitions challenging Environmental Protection Agency rules on persistent, bioaccumulative, and toxic chemicals under the Toxic Substances Control Act, upholding the agency's case-by-case review process rather than categorical bans as not arbitrary or capricious. The Ninth Circuit also affirmed 3 tax matters. Andy Ateje's failure to substantiate casualty losses and vehicle deductions under Section 165 and Section 274 to Rabendoc's pro se tax refund claim barred by the tax court jurisdictional statute, and a motion to vacate judgment for fraud on the court denied due to the high burden not being met. Finally, in the Federal Circuit, the court affirmed a dismissal for lack of jurisdiction over tort claims against state officials under the Tucker Act, dismissed 2 appeals for failure to pay docketing fees or file required discrimination statements, and dismissed an appeal from the Veterans Court as untimely filed beyond the 60-day statutory window. Back to you, David.
That wraps our broadcast for Wednesday, August 26, 2026. Thank you to James Taylor, Aisha Johnson, Michael Reeves, Maria Santos, and Raj Patel for their coverage today. The most significant outcomes included reversals, vacated decisions, and remands that will shape the legal landscape in several key areas. Across the docket, we saw 36 affirmances, 14 dismissals, and 11 other dispositions. Several appeals were dismissed on procedural grounds. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Subscribe and follow us for your daily update.